Hi, this is Jim Cunningham. Joint versus separate trusts for married couples. Which is right? I don't know. It depends, right? That's what lawyers always say. It depends. But we're going to get into the reasons when lawyers would recommend a separate trust versus a joint trust. And a lot of people ask me, when you do this stuff all day, you're like, I don't even know there's some basic questions like, shouldn't everyone have a trust? Like everyone has a will? Like you should have your own separate trust? Well, not always. And it really depends if you're in a community property state or a separate property state. And we'll talk about what that is. Joint trusts are for the ours couple, meaning if you're a couple and it's ours, right? So it's not like one spouse and the other spouses has their separate money and you have community money. But if a lot of times clients have been married a very long time and they say, look, we acquired everything during marriage. It was all from earnings and savings, no inheritance, no gift. It really kind of looks like community property. A joint trust may be appropriate. Joint trusts can be less complex to administer after the death of the first spouse. They can also have some tax advantages because in California and other community property states, again, depending on each property's, the laws of each state, but on a very high level, community property gets a full adjusted cost basis at death. So if you bought something for $100,000 and it goes up to $1 million and it's community property, one spouse dies, the other spouse can sell that $1 million asset and not pay capital gains tax. So that's what adjusted cost basis means. Separate trusts, on the other hand, can provide greater control, privacy, and flexibility. And typically we see this for second marriages. Sometimes it might be a first marriage if there's significant wealth that's brought to the marriage or inherited wealth. So generally we see second marriages. That's when you'll see separate trusts. So S is second marriage, S is separate, way to remember it. And remember, all these estate plans, these trusts should be tailored to the individual person's needs. There really is no form for a trust. We do have a statutory will in California. We have a uniform statutory form power of attorney. We also have an advanced healthcare directive. Those are actually forms in the probate code. By statute, there is no form of a trust. So a lot of people think, well, it's just a form I can fill out. Well, no, because there is no form, right? Unlike wills and unlike powers of attorney. And a properly crafted plan can help avoid taxes, reduce sticky administrative processes, and minimize conflicts among beneficiaries. I've got an image here of the Wizard of Oz kind of pulling back the curtain, which is kind of what we try to do with these webinars and these podcasts, is why do lawyers recommend separate trusts for couples at all? Like, what's going on? Well, the real reason is lawyers don't want to get sued, okay? So if a client comes to a lawyer and the lawyer says, oh, that's separate property, or that's community property, and identifies it as such and documents it, if for some reason it was separate property that became community and then that spouse divorces, right? That couple divorces, that lawyer can be held liable, personally liable, for the amount of damage that the person who brought the separate property to the marriage when they transmuted it to community property. There are actually cases out there that say, yes, the attorney can be held personally liable for that. So what you will see is if it's a couple going to one lawyer, there should be a reticence for the lawyer to change the character of property from separate to community. That's very, very important. I would say less experienced lawyers, less nuanced lawyers don't really get that, but be prepared. If you have separate property and you go to an estate lawyer, it may be that you have to go to your own lawyer. Sometimes there are 3 lawyers involved in an estate plan. That may sound like overkill, but really this is the reticence on the part of the lawyer who's representing the couple, right? And that's why I kind of use the analogy of pulling the curtain back on the Wizard of Oz. You can think of joint trusts as being trusts for community property. And if couples come to the marriage with their own trust, right? So, 2 people get married, they each have their own living trust. They have to update those, right? They have to acknowledge the fact of the marriage, which is, we covered that in other videos. But that couple that each has their own separate trust, they may actually create a third trust, which is the community property trust. That's a joint trust to hold that community property, meaning that marital property. So another reason to have separate trusts, by the way, is if it's a step-parent, step-child situation and a parent passes away, a spouse passes away, the stepkids aren't necessarily entitled to see a copy of that trust. If you have a joint trust, they typically are. So again, very high level, broad rules. So if you're concerned about your stepkids, you might want to be looking at separate trusts. I'm Jim Cunningham. I'm a partner at Cunningham Legal, over 25 years experience. We have offices throughout California, and I'm a certified specialist in estate planning, trust, and probate law, real estate broker, securities and insurance licensed, and a pilot. We have many lawyers at our firm who are here to serve our clients with all things estate planning, trust administration, and real estate. So very heavy emphasis on real estate and sort of multi-generational wealth creation. If you're watching this on YouTube, please subscribe to the channel. If you're listening to this on a podcast, please subscribe to our podcast so that you will be updated, right, and notified. We do these typically about once a week. Disclaimer, I'm a lawyer. I'm talking. This is not legal advice. Don't listen to this and go out and do a bunch of stuff. You absolutely should seek out competent legal counsel. If you'd like to, you can reach out to us, and you can find us on the web, Cunningham Legal. We're pretty easy to find. So joint versus separate trusts for married couples who are alive and healthy, okay? So I guess if you're dead, you're not a couple, you're a surviving spouse and healthy. So how many kinds of trusts are there? Well, I stopped counting at 31 because there's 31 flavors of ice cream, right? At 31 flavors. What we're going to focus on today is the revocable living trust. So we're going to focus on one of these 31 trusts, just the revocable living trust. So how does a revocable living trust work, or how do revocable living trusts work? You can just mentally think of a bucket, right? And the bucket has a handle. And so the people who create the trust are the people who set up the bucket. Really, it's not a bucket, it's a document, but you can think of it as a bucket. And there's a handle, and the trustee holds on to that handle and is in control of what's in the bucket. Now, the second you create a trust, there's nothing in the bucket. It's empty. You have to fund the trust. What does fund the trust mean? Fund the trust means a deed that transfers title from your name individually to you as trustee of your living trust. And you might need to transfer your stocks, your bonds, your mutual funds, typically assets. You might own some shares of an LLC, whatever it might be. You are funding those assets to your living trust so that it goes from outside the bucket to inside the bucket. The advantage is when the trustee stops being trustee, if you die, you can't be trustee, right? That passes to the next successor trustee. If it's a joint trust and the married couple is the two trustees, the co-trustees, one spouse passes away, typically the other one continues on as sole trustee. So that's where those terms kind of come from. Not really a successor trustee, but it's a sole remaining surviving trustee. Assets that don't go in the trust are your IRAs, 401ks, life insurance, annuities, and that ownership typically stays out of your living trust. All trustees have three things: a trustee, a beneficiary, and while you're alive, you're the beneficiary, right? If you're a married couple, if it's a revocable trust, and a corpus, which is stuff. It's going to be, stocks, bonds, mutual funds, your house, that's your stuff. That trust holds property while you're alive, and it helps to avoid probate at death, because if you don't have your stuff in a bucket, you need a court order to get that property to the surviving spouse in many cases, right? And also to the kids or other loved ones. Now, there are some strategies we can use. We can incorporate into the structure of this bucket to protect the assets from future ex-sons-in-law and future ex-daughters-in-law. Very important for many clients. It kind of makes sense, right? Half of all marriages end in divorce. So it makes sense to pay attention to that if you're leaving, in this example, to your children. And revocable trusts typically become irrevocable. So a revocable trust is a trust you can revoke, you can amend. Those typically become irrevocable at death, where you cannot amend it, you cannot revoke it. And if one spouse passes away, it depends on how that joint trust is written. We'll talk about that in a little bit, but it depends on how that trust is written. You may need to give a copy of the trust to your stepkids, right? Or not. It depends on how it's written. So it's very important to pay attention to that. So Hal and Wanda create a living trust. They create this bucket. Hal and Wanda are holding on to the handle as trustees, and title to the property often reads Hal and Wanda Lopez, trustees or successor trustees of the Lopez Trust, dated July 6, 2023, the day we're doing this webinar podcast, and any amendments there too. So you will see the name of the trustee, the individual trustees identified, and the name of the trust. So not just the Lopez Trust or whatever it is. You transfer your bank accounts into the trust, and typically it will say Hal and Wanda Lopez, trustees of the Lopez Trust, dated July 6, 2023. The bank may also ask Hal and Wanda who the successor trustees are. Now, this is very important because you need to name successor trustees, right? It's something you should be doing in your document, is saying who handles things when you're unable to handle them. And similarly, you transfer brokerage accounts and other LLC interests and what have you. That is what we call foundational estate planning. If you have not got that done, and this is something where you go, yeah, I need to get this done. Newsflash, it is part of adulting. If you're an adult, you need to get this stuff done. We can certainly help you out with that. Things that don't go, some other things that don't go in the trust. What do Hal and Wanda do? They have an estate plan, life insurance. Wanda oftentimes is the primary beneficiary and the trust is the secondary beneficiary, meaning if Wanda's alive, she gets the cash. And if she's not alive, it goes to the living trust. That's a very common strategy. Certainly you could name the trust at death. There might be some reasons why you would want to name Wanda. We covered that in other webinars. And IRAs, typically you're going to name the spouse, the surviving spouse as the beneficiary. Typically individual children, Sam and Deb. Hal has removed his ex-wife, and I want to mention this because if you have an ex-spouse, in California at least, when you have that final divorce decree, your ex-spouse is no longer lawfully under law the beneficiary of a life insurance policy, of an IRA, of an annuity. However, you, right, as the owner of that asset, have to go to the institution and remove your ex-spouse. This is very, very important. I can't tell you how many times we get calls from people. They say, I can't believe it. The ex ended up with the IRA. And there's nothing really, you got to go after the ex to chase the money. Yeah, you have to sue somebody. So, these institutions aren't necessarily aware that there's been a dissolution of marriage. So if you have a divorce, really pay attention to that. Typically the 401k, Wanda is the primary beneficiary as a spouse. That is a statutory beneficiary under federal law. If it's a 401k, it's an ERISA plan. But what if the ex is named as beneficiary? Again, you want to change that. It's kind of a race down to the institution to with the death certificate to get the money. And I would also say if you have an IRA or 401k that's over $1 million, over 500,000, there's some additional planning that we can do specifically for kind of having a plan, because that's a very large asset. If someone's inheriting 500 grand on an IRA, you may want to consider some additional planning. That's the IRA Legacy Trust. And again, we cover that in other webinars. So annuities, non-qualified annuity, Hal is the owner and annuitant. Wanda is the beneficiary. It's very important. Pump the brakes. If Hal has named the trust as beneficiary and not Wanda, there are a lot of tax advantages to having Wanda as the beneficiary. Again, kind of outside of the scope of what we're talking about, but very important to pay attention to. Don't just knee-jerk make the trust the beneficiary. That really requires some thought. So why do people use trust to begin with? Why are we using a living trust at all? They can be used for a variety of purposes. And really what we're talking about here is estate planning for the couple, potentially some tax planning for the couple, meaning if one spouse dies, can the surviving spouse sell all the assets and avoid capital gains? Many of our clients that do an estate plan in our firm, that is the result, not all, but many. And then asset protection. And when we talk about asset protection, we're really talking about it within the context of protecting the inheritance from future ex-sons-in-law and future ex-daughters-in-law, which I view as the chief threat, second to taxes, right? Taxes only takes half, right? Or maybe a third or whatever it ends up being on a dollar basis. But that divorce, you can end up with, maybe even more than half, who knows? Trust can also be useful to avoid probate, protect your legacy, minimize taxes. It provides a vehicle for managing your assets. If you have a minor beneficiary, maybe you have a child who's 5, and if something happens to you, who's going to manage that money, right? You have to go to court and do a guardianship to manage that money. A living trust is a much better alternative. And really, people do estate planning using living trust fundamentally for peace of mind. You want to make sure that you're doing the proper adulting. You want to make sure that you're getting all the things done you need to get done as a responsible parent or a responsible spouse or whatever the case may be. So very, very important. So what is an estate plan? So we talk about a living trust. A living trust is part of an estate plan. So a living trust, we all have a pour over will. Now, each person has their own will. We don't have joint wills in California. You might need to nominate a guardian for a minor child. And then pay attention to your beneficiary designations that we discussed. A durable power of attorney deals with everything that's not in your living trust. And I just saw an article come through on the continuing education wire, I guess news wire, that somebody did a power of attorney, a lawyer did a power of attorney, did not give the agent, who's the person that's serving, who's doing under the power of attorney, right? So I name someone as my agent. That person does for me when I'm alive, but I can't do for myself. Did not give that person the power to file income taxes. That's pretty basic, right? That is a real mess up. But we do see from time to time that lawyers omit certain powers. So it's very important. You need to give somebody the power to file your income tax return. Otherwise, you're subject to interest and penalties and a bunch of other bad stuff. HIPAA authorization. So durable power of attorney covers things that are outside of the trust. That durable power of attorney dies with you. The living trust continues on. A little bit of nuance there. You can't use the power of attorney after somebody's died. HIPAA authorization gives access to medical information. You can list people, whoever you want to have access to your medical information. Advanced Healthcare Directive talks about naming who makes healthcare decisions for you when you can't make them, right? So if I'm unconscious, I can't make healthcare decisions for myself. I'm going to name an agent under the Advanced Healthcare Directive to make those decisions. So an estate plan, again, avoids probate, saves taxes, protects your legacy. That's why people do estate planning. And for spouses, I want you to just sit back. If you're married, think about this. What happens when your spouse dies? What if your name is not on the deed? I got to tell you, that could be a real problem. So if you're sitting here listening to this and you're thinking, yeah, we're married and my name's not on the deed, you need to take a look at that. Okay. Will that property pass to the surviving spouse? The surviving spouse implies that there is a deceased spouse. So what we're talking about here is after the death of one spouse, we talk about the deceased spouse and the surviving spouse. Okay. How does the surviving spouse inherit? Is it outright, meaning do you just get it? Is it in some trust with some strings attached? Do you have to go through probate? Many times, if a spouse is not named on a piece of property, that surviving spouse has to go through probate court. Now, whether you do a full-blown probate or you're doing some other type of abbreviated process, bear in mind, going to probate court's a total hassle, okay? And it's good to avoid it, but really pay attention to this. Who takes care of the kids? You know, if these are stepkids of yours and there's another parent, there's no guardianship in California. Those children go to the other parent. That could be very disruptive for the kids. So what about incapacity, right? What if your spouse doesn't die but becomes incapacitated? Who's making the medical decisions? Who's making the financial decisions? What if you have adult stepchildren and your spouse has no plan at all, and that spouse gets sick and can't make healthcare decisions for himself or herself? Who's going to make those decisions? So California recently had a change in the law, medical proxy recently. These are not easy questions. It is much better to be clear and have an estate plan. So you have a choice as a married couple. And by the way, each spouse makes their own choice. So this is something to be very clear. So when a couple comes in, we make it very clear to the couple, if the need should arise to make it clear, that each spouse can leave his or her half of the community property however they want, and certainly all their separate property however they want. All right. So if spouses disagree, sometimes those estate plans, they don't necessarily reciprocate. They might look slightly different. So really the first question, threshold question, and this really drives the decision-making on whether to use a joint trust or separate trusts, or maybe a joint trust and separate trusts, right? If everything's going to the surviving spouse, what's the best way to do it, right? And if you say, look, the door swings both ways. If I die, my spouse gets it. If my spouse dies, I get it. That's just the way it is. And the survivor can decide however the survivor wants to leave that. That is a perfectly acceptable estate plan for many clients. And in fact, we write many of our estate plans like this because the clients say, look, if it's a survivor, it's yours. You do whatever you want with it. I'm gone, right? I'm not on earth anymore. I'm someplace else. Then the question is, well, should the children get some money or some type of inheritance? And then how much, right? And this comes up in, a lot with retirement accounts. We have many clients have a large retirement account. Say a client has a $2 million retirement account. And they say, well, if I leave it to my spouse, my kids are going to have to wait till my spouse dies. Maybe I'll leave my spouse $1 million and I'll leave my kids $1 million, right? That would be an example of leaving something. It's outside of a trust. Or you might say, I brought these rental properties to the marriage. Maybe I inherited them. It was a separate property of a prior spouse, right? So I was married before and that spouse passed away and then I inherited those. But really, I don't think it should go to my new spouse. It really should go to the kids because that's their other parent, right? So I think it requires legal counseling, right? For lack of a better term, we are counselors at law as estate planning attorneys. And then the other alternative is maybe the kids in this, or other loved ones, but the kids in this context get all of your estate. Now, this happens not often, but it does happen, where somebody might marry later in life and they say, look, we're each independently wealthy. If one of us passes away, let's just leave it to our kids. So A lot of different ways to go on that, but that's really the threshold question. And answering these questions helps drive whether to do a joint trust or a separate trust. We do have to understand community property for estate planning purposes. It is different than divorce, okay? So spouses can leave all of their separate property. So if I bring property to a marriage, I can leave that property to whomever I want when I die, plus half of my community property. So half of the community property. So only spouses can own community property in California. It is owned 50-50 by each spouse. And I can choose to leave my half of the community property however I want. And it matters whether it's community or separate property. It matters differently at divorce or death. And what I mean by that is at death, typically lawyers will say title controls. If it's joint tenancy property, the surviving joint tenant gets that property. If it's titled as community property, it is community property. In a divorce context, a judge can look at the title and say, well, I know it's joint tenancy property, but really it's community or whatever it is. So rules are slightly different at divorce, at death. So what we're looking at is the death rules here. In general, all property acquired during marriage is presumed to be community property, except property acquired by gift or inheritance, okay? And that property is not transmuted. What is a transmutation? A transmutation is, I have my separate property. Honey, I love you. I'm going to treat this as community property and I'll pay some community property bills. That might be enough for a transmutation. That's an oral transmutation or a pillow talk transmutation. So very important to pay attention that separate property can easily become community property, but it's really hard for a community property to become separate property. You really need like two other lawyers, like each person gets their lawyer. There's a writing. It's kind of a big deal. It's a big production. Community property, it's the opposite, right? It can easily become community property from separate property. So separate property, again, brought to the marriage, includes gifts during marriage, and can easily be transmuted to community property. California is a community property state. And again, everything acquired during marriage is community property, except through a gift or inheritance. So if you are working and you're married and you do not have a prenup and you take your earnings and you go buy a piece of property or you start a business, just because it's in your name does not mean that it's separate property. That very well will likely be deemed community property in the event of a divorce, but not necessarily in the event of death. And so that's why it's really important to pay attention to title in estate planning. So if you want that adjusted cost basis, if you want that really big tax benefit when somebody passes away, you really need a savvy expert lawyer. We cover this in my book, Savvy Estate Planning. You really need someone who knows what they're doing in order to get you to the right result, right? Because if you don't do it correctly, you're leaving potentially a lot of tax benefit on the table. Community property states are typically the Southwest, or West and Southwest, Washington, Idaho, California, Nevada, Arizona, New Mexico, Texas, Louisiana, and Wisconsin. There's some other kind of optional community property states, but those states have some real significant tax benefits. So if you're living in California and you say, gee, I'd really like to retire in Oregon, Oregon is not a community property state. You're not going to get an adjusted cost basis on marital property as an Oregon resident. You really need to pay attention to this. So if you have a lot of properties in California, that's something you're going to work with a lawyer on. If you're in Illinois and you're like, what? We don't get an adjusted cost basis. There are some things you can do where you can maybe go to Tennessee or Alaska and you can essentially manufacture a community property trust. That's kind of outside of the scope of what we're talking about here, but bear in mind, community property states significant tax advantages. So example of community property, Hal and Wanda marry. Wanda brings $100,000 to the marriage. After marrying Hal and Wanda, they buy a home and take title as joint tenants. If they divorce, a court will decide what's community and what's separate property. And at death, whoever the survivor is gets the property. This is the point of title controls. So if they get a divorce, Wanda may be entitled to her $100,000 back, right? But if they die, whoever the survivor is gets the property. Now, if they buy a piece of property, again, Wanda brings $100,000 to the marriage and they acquire this property with the title of community property. And this is why it's really important to pay attention to titling when you acquire real estate. That is community property, meaning if they divorce, a court will likely treat this as community property, 50-50 division. At death, the will determines who gets the deceased spouse's half of the property. Very, very important. It's not survivor takes all. And if it's a joint revocable trust, again, a court will decide what's community versus separate, and the living trust decides who gets the property. So all property that is community property, if you're a California resident, gets an adjusted cost basis. So it is not automatic. Assets must be valued. You should consider, if you've lost a spouse, consider filing a portability 706. We cover this in other webinars. That is a federal estate tax return. And there are deadlines on that, so you really need to pay attention to it. You can leave $12.92 million free of tax in 2023. That's getting cut in half in 2026, probably down to $7 million. Why is this important? Because we don't know what's going to happen with death taxes. I'm a firm believer that I think the taxes are going up, broadly speaking. We've just gone through a cycle of inflation. That's a form of taxation. We're going to go through the biggest transfer of wealth in human history here. We're in the middle of it. Is the government going to want more money? Yeah. I mean, come on, folks. This is a great opportunity to pick up a coupon that leaves you almost $13 million of a freebie, right? Tax-free when the surviving spouse passes away. We cover this in other materials, but I would say the most common mistakes are failure to appraise property. So people who just don't pay attention, they don't appraise the property and they don't file portability. This means meeting with a lawyer. If you've lost a spouse, this means coming in, you've got to spend some money. That's just the way it is, but you're going to get a tremendous tax benefit. So not automatic. So should you use a joint trust or a separate trust? For a married couple, most couples want to provide for their surviving spouse. I guess some don't, right? And distribute the remaining assets to children upon the second spouse's death. This is kind of what we see. This is like if it's an ours trust, like, hey, it's just all ours. And if one of us passes away, then it's all yours. And then when that happens, it all just kind of goes to the kids, you know? That would probably be a joint trust. I would say, joint trust makes sense. Probably a little bit easier to deal with. And that's, a lot of people, that's how they view it. But what is a joint trust? A joint trust is a single trust holding assets of a married couple. And it contains instructions for managing and distributing marital assets upon the death or disability of one or both of the spouses. So it will say on the death of one, or should say, on the death of one spouse, what happens? Well, it all goes to the surviving spouse, and that surviving spouse can change this trust. That trust never becomes irrevocable, okay? I would say lawyers view joint trusts as appropriate if we're treating the spouses as a unit. And this aligns with the client's understanding of the ownership of the marital property. So if the clients come in and they say, yeah, it's ours, we've been married 50 years, we're not going anywhere, I can see the case for a joint trust. Not always, right? But I can see the case if you're in a community property state for a joint trust. Funding a joint trust is typically funded with assets of both spouses. So community property is the property of both spouses, of the community, right, of the marriage. Separate property and community property retain their respective statuses unless the trust dictates otherwise. So many lawyers are reticent. They will have a schedule of property. So you might have a Schedule A, which kind of lists the property as the date the trust was funded, which, by the way, doesn't carry a lot of legal weight, but helps us know what's in there. And also, if someone passes away and that asset doesn't happen to be in the trust when the person passes away, there's kind of a shortcut court proceeding that hopefully is just one hearing. It's not a 2-year process, a full-blown probate. Those are the Hegstead and Uxted cases or processes or petitions. And, typically upon the first spouse's death, something called the survivor's trust is created. The survivor's trust, in this case, if it's a joint trust, and there's no separate carve-out irrevocable trust, it all goes to the survivor. The survivor can do whatever the survivor wants with the trust property because that spouse is deceased. The survivor can amend, restate, or revoke the trust. Now, whether to choose joint trust versus a separate trust largely hinges on whether the trust is in a community property state or a separate property state. I would tell you that in separate property states, we do see separate trusts as kind of the default. And separate property trusts can provide better asset protection. Okay, they can, not always, they can provide better. So if that's a concern, that might be a driver on why you might want a separate trust, why you might separate trust. In California, it's kind of minimal protection, but it can, there's a little bit there in certain cases. And I would say, again, lawyers view joint trusts as consistent with the client's view of their marital property. Is it mine? Is it ours? Is it yours? For a lot of men, it's I don't know, who knows, right? Is it ours or each spouse's own half of the property? Again, separate spouses or separate trusts in a separate property state can provide a little bit more asset protection. And a separate trust can be easier to administer after one spouse's death because sometimes if there is a split, and I would say if there's a split, between an A trust or an A and a B, or an A, a B, and a C, it can be kind of difficult to understand the trust from a layman's or a non-attorney's point of view. It can also be difficult to understand it from an attorney's point of view, right? Because you have a lot of conflicting provisions, and many times we have to do what is called an abstract of trust, where we pull the paragraphs out and essentially rewrite a new trust so that it can be read. So I think the case can be made. Simplicity, if there's no split, a joint trust is simpler, but if you're going to do an AB trust or something like that, separate trust can be easier to administer. Again, a joint trust in a separate property state, you can do it. We really don't see this a whole lot. I think legal fees may be the driver, but what I understand from my colleagues in separate property states, so not all these community property states, you might find that the lawyer's recommending separate trusts or a joint trust if fees are of a concern. And in community property states, trusts are typically joint trust. It allows you to maintain the community property character, and this is where you get the tax benefit, is all those assets in that trust. If you say, hey, it's community property, you get an adjusted cost basis at death. Again, if you're bringing property to a marriage, a knowledgeable lawyer is going to pump the brakes and be like, wait a minute, you brought this property to the marriage. I think it's separate property. You need to go see your own lawyer before you want to do a transmutation from separate to community to get that postmortem or death tax benefit. Again, separate property states, separate trust can be better for married couples. In community property states, what we typically see is a joint trust. So I would say, on being very general, separate property states, separate trust, community property state, joint trust. This is if the spouses are treating it as ours. Now let's talk about death of a spouse. So what happens when a spouse dies? Well, this is really important because death is a triggering event. Now, sometimes the death, apart from the loss, right? What I'm talking about is, are there stepkids? Is there trouble in the family? Something to understand is when a person passes away, when a trust becomes irrevocable, the US Constitution requires something called substantive due process or procedural due process. It's in the 5th and 14th Amendments, meaning it's notice and an opportunity to be heard. What this means is if someone is getting disinherited, they have a right to see the document that's disinheriting them. Now, if you're listening to this for the first time, if this is the first time you've ever heard this, you might say, what? Someone who's disinherited gets a copy of the trust? Are you kidding me? Yeah, that's the rule pretty much in every state. So when a spouse dies, if any part of this trust becomes irrevocable, okay? Now, typically, if it's a separate trust, it's going to become irrevocable. If it's a joint trust, it might not. But if any part of this trust becomes irrevocable, all the people named in the trust and all the people who would inherit if there was no trust are entitled to a copy of the living trust. They're entitled to a copy of that living trust upon request. So you don't have to give it to them, but they're entitled to it. And a time period does apply. It's a 4-month time period. And there's a requirement. Now, in some situations, this is not a big deal. If it's a happy family and you guys all get together at Thanksgiving and 4th of July and everything's fine, not going to be a problem. But in other situations, is what we call no bueno. It is downright frightening, okay? It's really scary, the thought of, we have this trust and my stepkids are going to see what's in my estate plan. I'm not comfortable with that. Okay, so this is where we start thinking about, well, maybe a joint trust isn't so good, right? Maybe we should be looking at separate trusts. So again, it's a little bit of a driver. Now, what I'm talking about here is California Probate Code section 16061.7. These are the notice requirements. The trustee, who may be the surviving spouse, who hates the stepkids, all right, see where I'm going with this, is required by California law to serve a notification when somebody passes away and a portion of that trust becomes irrevocable. So this is very important to understand. Does your trust become irrevocable when somebody dies or not? It might not. It depends on what it says. How do you know? You got to go see a lawyer, right? There's really no way around it. It has to be served on each person named in the trust and all the people who would inherit in the absence of a trust. Now, you may say, well, let's see, if my spouse died, I inherit everything. If there is no estate plan, the children of the deceased spouse, who are your stepkids, are entitled to inherit maybe half the property, maybe 2/3 of the property. It depends on how many kids there are. They have a right to see that trust, and that's of the separate property. So surviving spouse, if there's no will, in California, surviving spouse gets all the community property and shares the separate property with the kids and the surviving spouse. So it has to identify who the settlor was, which is the creator of the trust, the date the trust was signed, and you have to give the name, address, and telephone number of each trustee. And if you're trying to hide from your stepkids, this is a real problem. You might want to reconsider who the trustee is. You have to give them this information and the physical location of the principal place of trust administration. That's where the day-to-day activities of the trust are occurring. And if the trust requires additional information, you have to include that, and a notification that the recipients are entitled to a copy of the trust. Now, what we do in our firm many times is we just send the copy of the trust, but not in all circumstances, right? Because if they wait until one day before the 4 months is up, then they've got 60 more days to challenge the trust. So this has to do with challenging the trust. What's the point of giving them a trust? Well, it's irrevocable. And if the stepkids don't like what the trust says, they can drag stepmom or stepdad into court and sue them right after your spouse has passed away. There must be this statement contained in the notice. You may not bring an action to contest this trust more than 120 days from the date of the notification, or 60 days from the date which a copy of the terms of the trust is delivered to you within that 120-day period. So that could go out as long as 179 days. Very, very important. A lot of people ignore this. A lot of people blow it off. You know, a lot of people say, Jim, I talked to my accountant and my accountant said I can just, I don't have to do anything. It's a trust. I just follow the terms of the trust. No, this isn't even written in the trust. The 16061.7, you're not going to see it in a trust. And you think an accountant's going to know this? And if you're an accountant, please don't take offense. But my point is, talk to somebody who knows what they're doing. Talk to a trust and estate lawyer. That's all our lawyers in our firm know all this stuff. You need to talk to somebody, because if you don't do what you're supposed to do, a court may remove you as trustee. Now, just think about that. Your spouse dies, you're the surviving spouse, and then a court removes you as trustee because you didn't do this. Again, this is a no bueno situation. You really need to pay attention to this. And this is why it's important. And if you're a lawyer watching this, a lot of lawyers watch these, you really need to dig deep on what's going on in the family situation. Because when I was a younger lawyer, I was like, oh, everyone's kind of, they're all kind of the same. No, I mean, you really need to dig deep and really think through and walk the client through what happens if one of you passes away. Is that jerk stepson going to come in and cause problems? So again, this is an area you really need. If you're a client or a person who's not a lawyer and you're like, hey, does my trust become partially irrevocable when I pass away? You really do need to take a look at this. And I'd recommend you do that with a knowledgeable lawyer. So we're going to talk about the second marriage. This is very common. So we have an example here, the Brady Bunch. There was a song that started before the show that kind of explained everything. So you could just watch one episode, and if you paid attention, you'd be like, oh, Mike and Carol got married, and they've got Marcia, Jan, Cindy, Greg, Peter, and Bobby Brady. For some reason, Marcia, Jan, and Cindy took the name Brady. I don't know why. It was 1969. Who knows? Mike's got 3 boys. Carol has 3 girls. They live in California. It's a blended family. So it's his kids and her kids. Mike and Carol create the Brady Trust, a joint revocable living trust that splits into 2 trusts on the passing of a spouse. Mike dies. Husband always dies. Mike's half of the property is held in trust for the benefit of Carol during Carol's lifetime. And after Carol passes away, the assets of Mike's trust pass to Mike's kids. I would say this is a very common kind of old school way to do it. And if you're watching a video here, we have a graphic. So you get the Brady Trust. It's a bucket. And the property is divided into A trust and a B trust. Now, the question is, what's community and what's separate? So that determination will have to be made, because the way these trusts typically are written, a well-written trust will say, all of my community property, I leave to my half of the community property goes to this separate trust. So Mike would say, my half of the community property goes to Mike's trust, the decedent's trust, and all of my separate property. Now it's a second marriage. They brought property to the marriage. Someone's going to have to figure out what's separate and community property. You can see this is maybe a little messy, because Carol's like, well, I think that's community property, and, it should be split 50-50. So I should get my half. But, the boys might say, well, wait a minute, stepmom, I think it was separate property, and all that money should go into dad's bucket and not be split. You shouldn't get half of that. So let's say dad had $100,000 in an account. The boys would say, well, that should be separate property, because that 100,000 goes into a trust ultimately for our benefit. But if it's community, only 50 is going in, and then 50 goes to Carol. So you can see where it's teeing up a little bit of conflict potentially. Also, after Mike passes away, the boys have a right to information. Now, so this is where it gets a little sticky. Carol is a lifetime beneficiary. Carol gets the income and maybe distributions for health, education, maintenance, and support. That's very common. But the boys are what we call remainder. Well, when I was in law school, it was remainder men. Now they're remainder beneficiaries. They're the remainder beneficiaries. So these boys will, when Carol dies, the boys will get whatever's left over. They have rights. They have rights to information. If she's mishandling the trust, they could bring an action to remove her as trustee. So they have some enforceable rights that can be presently enforceable, even though they don't get theirs until Carol dies, right? So another way of, again, so after they're both gone, then Mike's half goes to Mike's side of the people and Carol's half goes to Carol's girls. But what if the boys said, oh, well, Carol was mismanaging the trust, or she, the trust that was dad's trust was somehow mishandled? There could be a lawsuit either while Carol's alive or after she passes away. Very common. And again, I'm just going through, I'm not even sure there's a solution, but I'm just going through a lot of the issues. This is when you have separate trusts, okay? But one way to mitigate this potentially is something called a joint pour-over trust. So what this does is this can help with this tough call of what's community and what's separate and what to break up into the buckets. So they create a living trust that does not become irrevocable on the death of the spouse. And well, a joint pour-over trust a little bit later. So what we're talking about here is they just create a living trust. They say, look, Mike says, if I die, it all goes to Carol. So I die, Mike says, I die, it all goes to Carol. And when Carol dies, it goes in sixths, 1/6 to each kid, and Carol could change it. So maybe she just leaves it to her girls. That is one possible solution, right? That keeps the kids, the boys, from bugging Carol, and they might actually be nicer to her so that she leaves them their inheritance. I'm not suggesting this is the way to go or better. I'm just saying this is a possible way to go. Mike can also leave his half of the property to the boys at his death if Carol has enough. If he says, well, Carol, you got enough, right? Or they can create 3 trusts. Now you might say, Jim, 3 trusts, you're just running up legal fees. How does this work? So 3 trusts. Carol's separate property is in Carol's own trust. Mike's separate property is in Mike's own trust. The only community property, right? The property that's community property is in this joint trust that just splits 50-50 at death. And this can help to solve the problem of when Mike dies, when Mike Brady dies, what's community, what's separate? How do we know what's community, what's separate? Because they've already defined that during their lifetime. So this is called a joint pour-over trust. We do this a lot for second marriages. It may be that Mike's trust just goes to the kids. It may be that that trust is held for Carol's benefit. Maybe Carol just gets income, right? Maybe she gets a certain amount, a dollar amount every year. Maybe she gets a percentage. Maybe she gets 4% of the value of the trust, right? Every year. Or there are a lot of different ways to write this. And that would be like a unit trust way of writing that. So there are a lot of different ways to go on this. And again, this is why it pays to meet with a lawyer who knows what he or she is doing, right? Because I will say the vast majority of estate planning attorneys have no idea what this is, okay? And this is not an uncommon situation. Ideally, what we're trying to do here is we're trying to promote family harmony. We're trying to keep this family out of litigation. And you can go to any probate court, and much of a probate court's day, their calendar is spent on probate litigation, people fighting after death. Okay, so something to be mindful of. That brings us to the end. I want to thank you for watching, and our offices are located in Northern and Southern California. So we have them in kind of the LA area and the Bay Area and the capital region, which is Sacramento. And if you would like, you can schedule a call, and there's no charge for the call. And that's just a quick to figure out, should there be a meeting? And that's not with a lawyer. So it's very important. So feel free to call in, and then you can schedule an appointment. All our appointments they're paid appointments. So there are no free appointments anymore. That's kind of a legacy of COVID, but you could certainly call and talk to somebody to see if it's a right fit, and we can help you. And next week, when and how to probate real estate properties in California. Okay. So this is if we didn't do a living trust, or we did a trust and the property's not in the name of the trust. We refinanced that property and it came out. What do you do? We're going to go through all the steps that you can do, what you can and what you can't do. The link is in the description. and it's in the chat as well. So you can go to our webinars page and subscribe to, or sign up for that webinar, and subscribe to our YouTube channel if you're watching this on YouTube. And we will finish it with some questions. But if you're watching this on YouTube, this is it. It's just going to roll to the next video and you won't have to do anything.